दोस्तों, जैसा कि आप तमाम लोग जानते हैं कि मुफ्ती सलमान अज़हरी साहब के मामले में कल अदालत में सुनवाई हुई। गुजरात हाई कोर्ट में 1 जुलाई को लगभग 11 साढ़े 11 बजे के आसपास मुफ्ती सलमान अज़हरी के मामले में सुनवाई शुरू हुई और उसके बाद लगभग 1 डेढ़ 2 घंटे के आसपास इस मामले में हियरिंग चलती रही। हम आपको गुजरात हाई कोर्ट की प्रोसीडिंग के कुछ वीडियोज़ दिखाने जा रहे हैं, जिसमें आप देख सकते हैं कि किस तरह से गुजरात हाई कोर्ट के अंदर जो है मुफ्ती सलमान अज़हरी के वकील ने अपनी बात रखी। हम आपको वो फुटेज दिखाने जा रहे हैं। आप इस वीडियो को देखिए और अगर आपको लगे कि ये बातें आपको सही तरीके से समझ में नहीं आई कि आखिरकार क्या कुछ बातें हुई हैं, तो आप हमें कमेंट सेक्शन में बताइएगा। हम ज़रूर कोशिश करेंगे कि इस पूरे मामले पर हम आपको और भी डिटेल में जानकारी दे सकें। देखिए ये कोर्ट के अंदर की प्रोसीडिंग जो कि लाइव स्ट्रीम की गई थी। देख सकते हैं आप इस वीडियो को।
कोई अभण હોય તો શેમાં દસ્તાવેજ આપશે?
Academically, just
there should be some arrangement of making him understand in his language. So I'm not.
no, person is totally illiterate.
So in a sense, there should be some arrangement made by the state to make him understand. Because unless he understands the language, the whole purpose of this judgment is, and this judgment is relied upon in so many subsequent judgments. So he is supposed to be. There is a movie, there is a movie, English movie, Amistad Curry. The same thing happened, and the senior asked, a junior comes to him. સ્પેનના લોકોને યુએસ વાળા બધા સમુદ્રમાં નાખી દે. Then the senior જે છે પાસે આવે છે, તો senior asks him કે what is their story? So he says there is a language problem and they don't understand our language, so we don't have any story. We are not able to communicate. Then the senior says that you engage a translator, get that story, and a story સાંભળ્યા પછી જ એ defense કરશે, as my lord does say. And then he says, after getting that story, whichever story is the best in the court of law would succeed.
In this case,
એની સ્ટોરી તો જાણવી જ પડે સાહેબ, અને એને આ કમ્યુનિકેશન જે છે એની લેંગ્વેજમાં, in the language in which it is communicated, અને એને એ કમ્યુનિકેટ કરવું જ પડે.
કઈ લેંગ્વેજમાં એને સપ્લાય કરે છે ડોક્યુમેન્ટ?
એમાં ગુજરાતીમાં કર્યા છે. He is knowing Hindi, Urdu, Arabic. He is not aware, and he is from Maharashtra.
whether he made a representation or not.
He made a representation. Even the ground was taken. Even in this petition, a ground is taken.
No. So far, representation is made in which language?
Representation.
Gujarati.
Okay,
That was done by the lawyer.
Yeah.
But
anyway, we are not just, we want to understand.
Please, now please see the order of detention, page 20, and he is labeled as dangerous person under 2. So in the order he says, "2C મુજબ ભયજનક વ્યક્તિ તરીકે અટકમાં લેવામાં જરૂરી હુકમ કરવામાં આવે." Then 22 are the grounds we see. And straight away I'll take my lords to 23. These are two offenses back to back. First offense of 2nd of February 24 at 23. Second of February 24 and the second of 6th of February 24. Now, along with this, these two offenses, my lord, they also rely upon some earlier offenses, old offenses, and that is at page 28.
29.
29. Old offenses. So these two offenses and these offenses at para 14 દેશે તમારી વિરુદ્ધ હાલમાં તથા ભૂતકાળમાં નોંધાયેલ ગુનાઓની તેમાં at page 14. Para 14, page 13. So So 29 are those offences, the old offences of 2015, 17, and then in para 14, they say that તમારા વિરુદ્ધમાં હાલમાં તથા ભૂતકાળમાં નોંધાયેલ ગુનાઓની તેમજ સાહેબોના નિવેદન તમે ગુના એ વાળા છો. So they arrived at a subjective satisfaction that you are habitual and you are a dangerous person based on these two offences and the offences which is at page 29, 1 to 8. And those are 2015, 17. And all these offences, 1 to 8, they are not forming part of the order of detention. So the material which is relied upon, again it is in Marathi, but it is not without part. And all these offences 1 to 8, I am told that have been acquitted. The draft amendment is also submitted to us, and that is allowed by the. That is also allowed. So, those offences are not forming part of, and even that stage at which the offences are there, there is nothing, no bail order, no FIRs, no charge sheets, nothing on record, and that is taken into consideration. So this is, again a non-application of mine. Now, one judgment of this honorable court, which is in the last it is criminal special civil application 6670/26. That is by Honorable Justice Supaya and Justice Devi. 7 number. Should have waited. Fortunately, it is not waiting.
Maybe a close margin. I am aware.
No, Bella. Only this. We are sorry for it.
No, check. I see. Yes, 3rd May 23.
3rd May 23. This actually covers the entire law. And all those earlier judgments are relied upon, and it starts from para 5. This is having heard in these two very cases, which was registered on 2nd of February, 6th of February. In these two cases, I was immediately granted bail. Those orders, because this is an ordinary law, the law says that if the ordinary law is not able to take care of a person, then only in extraordinary situation this preventive detention can be taken. Here, I was released on bail. And thereafter, I was immediately detained within no time. They did not, make an attempt to challenge that order initially before my detention. Subsequent to my detention, only with a view to cover up those things, they have challenged the cancellation. Now, once they have filed cancellation, the cancellation can certainly take care. The ordinary law can certainly take care of the situation. Where is the question of, preventive detention? So once an ordinary law is able to take care of a situation, then there is no question. Now, since they have moved a cancellation, so they are taking steps. So where is the question of detaining me? And it's February, 16th of February, this detention order is passed. We are in July. And the cancellation has not proceeded. So it is only with a view to detain, This is, an outright abuse of process. because the ordinary law could have, my lord, taken care of the situation. But this extraordinary law was used for any motive which is best known to them. Now please see para 5. Having heard the learned advocates for the parties and considering the documents and material available on record of the case, prima facie it is found that subjective satisfaction arrived at by the detaining authority cannot be said to be legal valid in accordance with law is in as much as the offences alleged in the FIR cannot have a bearing on the public order as required under the Act. And mere apprehension can't be the basis of passing and using this draconian law. And other relevant penal law cannot have any bearing on the public order as required under the Act. And other relevant penal laws are sufficient enough to take care of the situation. And that the allegations leveled against the petition detainee cannot be said to be germane for the purpose of bringing the detainee within the realm of Section 2C of the Act. Dangerous person. 2 FIRs of 153B, my lord, dangerous person. Germane to so and so detainee within the realm of 2C, unless and until the material is there to make out a case that a person has become a threat and menace to the society, so as to disturb the whole tempo of the society, and that all social apparatus goes in peril disturbing public order at the instance of such person. In that circumstances, it cannot be said that detainee is a person which would fall within the meaning of duty of the Act, except general statements. There is no material on record which shows that the detainee is acting in such a manner which would become dangerous to the public order. Then, my lord, please come to para 6. Again, a judgment is referred. Now, please see, it says, para 6.1, in so and so, the apex court has held that such a right in fact could not have been withheld by the sponsoring authority before the detaining authority. In the present case, though the detaining authority was aware of the fact that the detainee is released on bail, in all these offences, the order does not anyway contain that the detaining authority has applied his mind to the aforesaid facts. This is my case. All those orders of bail were there on record. The apex court observed as under in the aforesaid judgment as noted above in the case on hand in both the cases relied upon by the detaining authority for the purpose of preventively detaining the appellant hearing the appellant was already ordered to be released on bail by the concerned special court. Indisputably, we do not find any reference of this fact in the proposal, but so and so the reason for laying much stress on this aspect in the matter appellant though arrested, and then, my lord, the whole judgment. And just below that, one over the page, my lord, in Asha Devi versus Sancho, the material or vital facts which would influence the minds of the detaining authority, one way or the other, on the question whether or not to make detention order are not placed before or not considered by the detaining authority, it would vitiate its subjective satisfaction, rendering the detention order to be illegal. Here, as I said, those offences were not on record. There was no document which could have, supposing, my lord, there were 8 offences which had influence. They are saying, yes, apart from these 2 offences, other 8 offences are also there against him. So he is habitual. Now, supposing those acquittal orders, those charge sheets were on record, certainly it could have influenced the minds of the
Detaining authority.
authority. Those admittedly, they are not even aware that whether they were acquitted or not. And they have relied upon simply. So that will, my lord, render the detention order to be illegal and the subjective satisfaction would get vitiated. Then from the above decision, it emerges that the requisite subjective satisfaction, the formation of which a condition precedent to passing of a detention order will get vitiated if the material or vital facts which would have bearing on the issue and weigh the satisfaction of the detaining authority one way or the other and influence his mind are either way withheld or suppressed by the sponsoring authority or ignored and not considered by the detaining authority before issuing the detention order. So that has to go. Now PC 6.2. When a person is enlarged on bail by a competent court, great caution should be exercised in scrutinizing the validity of an order, preventive detention order, which is based on the same charge which is to be tried by criminal court. It is also noticed by this court that the order does not refer to any application for cancellation of bail having filed by the state authorities. Now, subsequently, they are filed. Then, my lord, 6.3. And then 6.4, it is mainly Ram Manohar Lohia. It is in respect of public order. So, the Constitution bench held, we have here a case of detention under so and so, which permits apprehension and detention of a person likely to act in a manner prejudicial to maintenance of public order.
If he is trying to raise complications. It is it for every while which he is continuing the same activity. Like I was આપણે જે રાઇટ ઓફ ફ્રી સ્પીચ છે એમાં 19 ની છે એ રિસ્ટ્રિક્શન એટલે આપણે કરી શકીએ. Yes.
Now, 6.4, my lord, it is in respect of this judgment, again a Constitution bench judgment, which my lord defines what is public order, law and order. And it says, we have here a case of detention under so and so, in a manner prejudiced public, mental public order. It follows that if such a person is not detained, public disorder is apprehended. That disorder is no doubt prevented by maintaining the law and order. But also disorder is a short fact, which includes one kind of small disturbances at other most serious and cataclysmic happening. Thus, the expression public order takes every kind of disorder. By the answer to this distinguish public order, law and order, because the later undoubtedly takes in all of them. Public order if discourse must lead to public disorder. Every breach of public peace does not lead to public disorder. When two drunkards quarrel and my lord, then apprehension, and then please come to 6.5. The first line of that judgment says, a mere apprehension of breach of law and order is not sufficient to meet the standards of adversely affects the maintenance of the law. And then again, my lord, over the page, Pushkar Mukherjee, and then comes my lord, thereafter para 8, Nageshwara Naidu. It is of 2012, my lord. Last three lines from para 12, page 12, my lord. Such detention order cannot be made a substitute to ordinary law and absolve the investigating authorities of their normal functions of investigating crime, which the detainee may have committed. It had also been observed that after all, preventive detention in almost all the cases for a year and cannot be used as an instrument to keep a person perpetual custody without trial. Then thus the Supreme Court has also emphasized para 9 that the preventive detention involves detaining a person without trial in order to prevent him from committing such types of offenses. Such detention cannot be made a substitute to ordinary law and absolve the investigating authorities of the normal functions of investigating crime, which the detainee may have committed if it had also been observed that all preventive detention, after all preventive detention, most of the cases is for a year only and cannot be used as an instrument to keep the person perpetual custody. And then it appears to state authority to forget the aforementioned settled propositions of law and order are being passed, being oblivious of the fact that the freedom of human being is supreme, and same cannot be curtailed or restricted unless the detention is extremely necessary and the activities of the detainee affect the public order. It is also noted by this court that state authorities are absolutely oblivious to the expression between the law and order, public order. In numerous decisions, the Supreme Court and the High Court has reiterated and explained the difference between two expressions. However, from the orders of the detention, it is noticed that no attention is being paid by the detaining authorities on such a vital aspect, which, while passing the detention order, the authorities have to be mindful of the characteristic of Article 21, 22 of the Constitution. 22 cannot be read in isolation, but must be read as an exception to 21, and such exception can apply only in the rare and respective cases. The Apex Code and this code time and again have articulated the personal liberty protected under Article 21 is so sacrosanct and so high in in the scale of constitutional values that it is the obligation of the detaining authority to show that the impugned detention is meticulously accords with the procedure established in law. We have also come across cases that in a single case of prohibition, the provisions of PASA are invoked and order of detention are not executed and provisions of PASA are invoked even after the detainee have been granted bail. Now here also, my lord, I have been granted. So after the bail is granted, detention. Ordinary law is able to take care, and here the same case, my lord, that after grant of bail, immediately, my lord, the day within few days after grant of bail, I was, and I was throughout in case. So second, there is first case, sixth, there is second, and the Murasa case was the third case was also there, and from jail itself, I was, my lord, detained under PASA.
Offense registered under 153. What would be the apprehension disclosed in the FIR? What would be the
My lord, there are
allegations?
speeches, yes, I'll show that.
No. We what I'm telling you, just whether that speeches would be such a gravity that
Absolutely not with great respect. There is nothing. Now the detention order says religious sentiments. The FIR says religious sentiments. If my lord may look into those my lord lines, that transcript, which is transcript is not provided to me, my lord. That is also, my lord. There is no transcript. Now, my lord. And what they have done, they have picked up certain lines from online, my lord, and they have relied upon that and passed the detention order. The whole thing, my lord, is not there. Now, please see, since my lords have put to me, my lord, I'll immediately point out what is this which can affect which can create a public disorder. Please see, the FIR is at page 1 of the paper book. And I was invited, my lord. I am staying in Maharashtra. I was invited by some, my lord, people here in Gujrat. And on that invitation, my lord, there were several, my lord, religious leaders. All of them gave speech. I also gave a speech. And on this I am taken. Please see.
page 5 of the middle of the portion.
Sir, page 5 side. Now please see 31/1/2024 ના રોજ જુનાગઢ રોડ સોનસો જુમા મસ્જિદની બાજુમાં નરસિંહ મહેતા સ્કૂલની ગ્રાઉન્ડના મલિક अन्य लोगों સાથે મળી મુક્તિ ધાર્મિક કાર્યક્રમના નામે કાર્યક્રમ યોજાયેલો અને નશા મુક્તિ તથા આયોજકોને મળી ઓલ અઝીઝ ચેરિટેબલ જુનાગઢ શહેરના આમંત્રિત કરેલા અને કાર્યક્રમમાં આયોજન થયું. અતિથિઓ પૈકી મૌલાના so and so. Now please see the last 5 lines. Search करी video check करता. Now please see. So there is no authenticity of this video. Google થી કઈથી download કરી લેવાનું અને video search કરતા this is. And in such casual manner, my lord, the detention order is passed relying upon a material which is unauthenticated, downloaded from a YouTube. How YouTube, my lord, if YouTube is relied upon, then, my lord, then nothing would remain. Now, please see.
In the FIR, the alleged FIR with the base of this detention order, wherein the charge sheet is filed?
Charge sheet not filed. I am told subject to the state. Now last 3-4 lines. Now please read it.
Yes.
Then please see just the next line, next page, my lord, 7, first line. Na samay so and so. Now, where is that 153B? A caution is filed wherein notice is already issued. In In my respectful submission, my argument before that court was that if this is taken as it is, where are the ingredients of 153B? My lord, I am just putting this because my lord put a query to me. Now, the second FIR also says the same thing. And they have downloaded it from YouTube. There is no authentication to that transcript, my lord. And this is the application of mine on a downloaded, my lord, transcript, and that too selective.
Why we are asking ultimately?
Please.
Yes, we since last 15, 20 days we are in this detention business. So we are occasioned to deal with so many judgment also. But in one of the judgment, Upendra versus State of Maharashtra,
Right.
wherein after referring the earlier judgment 1972 or something onward, whatever it, in para 8 of the judgment, some of the distinctions being discussed and explained, and the sum and substance of the judgment, rather dictum of the law,
Right. Public order.
That public order, but the act by itself,
Right.
therefore, is not determined of its own gravity.
Right.
In its quality, it may not differ from other similar acts, but in its potentiality, that is, in its impact on the society, it may be very
The true test is not the kind, but the potential
very
of the act.
different.
One act may affect only individuals. The other, though of similar kind, may have an impact on it, would disturb even tempo of the life so and so community. This does not mean that there can be no overlapping in sense that an act cannot fall within two concepts at the same time. An act, for instance, affecting public order may have an impact, and that would affect the public order and security of the state. You know, it goes to the extent of saying public order and security of the state.
Right.
So where is the question of security?
But in that Ram Manohar Lohia judgment itself, Honorable the Apex Court has made it clear that if a person tried to raise communal passions,
right?
Now, you have skipped that speech
from the FIR.
તમે એ નથી વાંચ્યું જે પ્રોગ્રામ છે so channel પર ચાલી રહેલ છે જે પ્રોગ્રામ you were invited in by some people of Junagadh, જ્યાં તમારું લેક્ચર હતું, તકરીર હતી, રાઈટ? એમાં જે વર્ડિંગ્સ છે.
Now, anyway, we are just only concerned with to understand
Certainly.
that whatever unauthenticated transcript of this speech,
public order,
whether it would be amount to a public disorder or not, that is the only question to be required. And on that count, whether application of mind on the part of the literary authority would be there or not.
Yes. Now, my lord, if my lord would see, since my lord has pointed out, whether there is anything which my lord attracts 153. And second part, whether the second part.
જૂનો આપો હવે.
The second part, on what basis?
One offense or 100 offense would not make any difference.
Absolutely.
Thing is, what would be the contents, the grounds relied by the detaining authority.
Very good. Very good. Now ground should be based on some material. Now that material can't be in air, Lord. It has to be a material which can be certainly, which is authenticated material.
By words.
153B. 153B.
By words, I get spoken or by signs.
national integration. It is, Lord, it says, whoever by words either spoken or written, visible, makes or publishes any imputation in class of persons cannot by reason of their being members of religious, racial, language, or regional group or caste or community bear true faith to an allegiance to the constitution as by the law established or uphold the sovereignty and integrity of the country. Then asserts, counsels, advises, publishes that any class of persons shall by reason of their being members of any religious, racial, language or regional group or caste or community be denied or deprived of their rights as citizens of India. Then makes or publishes an assertions, counsel, plea, or appeal concerning the obligation of any class of person by reason of being members of religious, racial, language, or regional group or caste or community, and such assertion, counsel, plea, or appeal causes or is likely to cause disharmony or feelings of the enmity or hatred or ill will between such members and other persons. If I say something, Lord, against the other community, then shall be punished 3 years. Whoever commits an offence specified in so and so in any place of worship or any other assembly engaged in performing religious worship, religious ceremonies, shall be punished with imprisonment which may extend to 5 years. So, where, my lord, there should be, my lord, some speech which is against a particular community, which can, my lord, bring hatred of one community towards others. One line, my lord, in this FIR can't even remotely suggest that this speech is falling within 153. It goes to the, my lord, integration of the nation, sovereignty and integrity of the country. Now here, back to back 2 FIRs, 3 FIRs, till the time I was out on bail, I was, my lord, taken from the judicial custody and, my lord, detained under preventive detention. They could have extraded me. I would not have entered the state of Gujrat for whatever powers they have. After release on bail, my lord, they could have, my lord, extend me out of the state of Gujrat. They have those powers. But no preventive detention. My lord, this at page 9, what we are reading is, this is a poetry, a share of a very, my lord, famous poet of this country, Raj Indori. It's nothing beyond that.
The last paragraph or the middle of the portion?
हुकूमत करने वाली सो एंड सो अपोजिशन में बैठने वाली पार्टी भी मसीहा नहीं हो सकता है चंद दिनों की सो एंड सो दैट इज ऑल.
So in Maharashtra, so far these 8 offences are concerned acquitted. So this is first time the invocation of provision of
Absolutely.
the
Very first time. And said in the bail condition, there is a condition at 181 in the paper book. Condition number 3, sir, of 181. Now please see 181. Where is it? One? Where is it?
Any particular condition?
એ તો બરાબર છે એટલે બીજો કોઈ ગુનો કર્યો નથી એમ કે છે
આરોપીને
એ કાંઈનો પાસ કરે તો
જીવન કરવા
બરાબર છે એટલે આપણે એક્સપ્રેસ નથી કરતા ના આપણે જનરલી ગૌરવ કરવાનું છે એનો પછી ના આપણે કોઈ આજે છે ચાલો સ્કીપ કરીને કહી દીધું ના ના તમે આજે છે ને લોકો આપણે રાત દૂર ના ના કેન્દ્ર itu aku setelah ini baru kita dia setelah kondisi wajib nah memang itu sebenarnya tukar sahabat itu ini kawan aku ini kalau kawan di proses seperti liberty proses seperti kawan ini share dengan Islam juga macam macam kerja macam macam ini apa bau perfect kerja
449 I am so sorry. 440. 453.
$453. Yes. 7.
453. 6 आरोपी ने चार्जशीट फाइल है ત્યાં સુધી દર મહિના પોલીસે નિયમિત હાજરી આપવી આરોપી ને ચાર્જશીટ ફાઇલ થાય ત્યાં સુધી સામખિયારી પોલીસ સ્ટેશનની હદમાં
પ્રવેશ કરવો
પુરાવા સિવાય આરોપીને પાસપોર્ટ ધરાવતા કોર્ટમાં જમા કરાવવું અને આરોપીને સાહેબની ભાગધમકી આપવા નહીં અને લોક અદાલત આપવી જાહેર સુલે શાંતિનો ભંગ થાય તેવું કોઈ કૃત્ય કરવું. So it takes care of that also. The bail order. અને સાહેબ 1 થી 15 તારીખે હાજરી પુરા એ રીતે એન્ટર થવું નહીં તો otherwise he should not enter that area. So the bail order itself is taking care of that. And if at all there was any breach, you could have moved an application which was subsequently. So on the very first ground this whole case will fall, that language, to the materials which they are relying upon, those 7 cases, 8 cases of Maharashtra, nothing is on record, including the acquittal order. That has influenced the mind
of the
authority, my lord, in one way, because the authority has arrived at a conclusion that habitual che, on the basis of those 2 FIRs and these FIRs. Those, my lord, were not at all there. So there is number 1, the sponsoring authority has not submitted to the detaining authority. So there is a suppression. Even as per the judgment of the Supreme Court, there is a suppression by the sponsoring authority, and therefore the detaining authority did not apply its mind on those documents which were not there. So this is not an application of mind, that simply a reference is given without document, and relying upon those references of the cases, without a detention order is found. And Lord 3, in my respectful submission, the bail conditions take care of the whole thing. The bail condition itself says that he will not enter that area, number 1. Number 2, he will not leave the country without the permission. Number 3, that he can there should be no, my lord, disturbance and એને કોઈ law and order situation કે કોઈ જે છે that also it takes care આરોપી ને જાહેર સુરક્ષા શાંતિનો ભંગ ના થાય એ કૃત્ય કરવું નહીં. So all those things, my lord, in a composite manner, my lord, would render the detention order to be issued. And my lord, 16th of February, I was detained. That too from judicial custody. The moment, my lord, I got released on bail, I was released. So that also, my lord, is an important and vital factor which may be taken into consideration. So, my lord, in my respectful submission, my lord, all those grounds will, my lord, render. And, my lord, he could have been externed from the state. I am not, my lord, a resident of Gujrat. I am from Maharashtra. My lord, in my respectful submission, the detention order made. And, my lord, one more thing. That the second FIR, which is of 6th of February, the incident is of 31st of January 24. And the FIR got registered on 6th of February. Because prior to that, on 2nd February, there was one FIR. Now, they wanted, my lord, more than one FIR so that I can be detained. So therefore, my lord, on 6th of February, there is another FIR and the incident is of 31st of January. And the moment I got released, and filing of cancellation, my lord, itself is a ground that even they believe that the ordinary law can take care of the situation. So where is the question of preventive detention? So, my lord, in my respectful submission, my lord, kindly exercise discretion and
तो दोस्तों देखा आपने ये गुजरात हाई कोर्ट के वकील गुजरात हाई कोर्ट के अंदर जो वकील हैं मुफ्ती सलमान अजहरी की तरफ से जो वकील थे उन्होंने अपना पक्ष रखा। जज साहब के पास अपनी बात रखी। आप देख सकते हैं कि 2 बेंच हैं यहाँ पर, जिसमें जस्टिस इलेश वोरा साहब जो हैं वो और जस्टिस विमल के व्यास साहब, ये दोनों ही जज साहब जो हैं वो इस पूरे बयान को सुन रहे थे, पूरे मामलात को देख रहे थे। आपको बता दें कि इस पूरे मामले के बाद फिर गुजरात हाई कोर्ट में जो अगेंस्ट में जो वकील हैं मुफ्ती सलमान अजहरी के जो प्रोसिक्यूटर हैं, उन्होंने भी अपनी बात रखी थी। हमने इसके बारे में आपको एक छोटा वीडियो बना करके बताया था कि क्या क्या मुख्य बातें हुई थी। तो ये पूरा का पूरा ओवरऑल एक तरह से कहा सकता है जो बातें सामने आई है। हालांकि इसमें और भी बहुत सारी चीज़ें हैं जो हमने आपको पूरा वीडियो के तौर पर नहीं दिखाया है, लेकिन खैर ये तमाम बातें हैं। बाकी जज साहब ने ये फ़ैसला दिया था कल के इस पूरे मामले पर, इस पूरे प्रकरण पर 8 तारीख को फ़ैसला सुनाया जाएगा। अब देखना यह है कि मुफ्ती सलमान अजहरी के मामले में 8 तारीख को क्या कुछ फ़ैसला सामने आता है। अब ये जज साहब के ऊपर डिपेंड करता है कि जज साहब ने इस पूरी प्रोसीडिंग को देखा, सुना, समझा। अब वो क्या फ़ैसला सुनाएंगे वो 8 तारीख को ही डिसाइड होने वाला है। आपको बता दें कि मुफ्ती सलमान अजहरी के लिए ये जो फ़ैसला है वो काफ़ी ज़रूरी है। अगर उन्हें रिहा किया जाता है तो ये बहुत अच्छी बात होगी। अगर ऐसा नहीं होता है तो शायद मुफ्ती सलमान अजहरी और उनकी जो लीगल टीम है वो सुप्रीम कोर्ट का दरवाज़ा खटखटाएगी। आप तमाम लोग इस वीडियो को देखने के बाद क्या कुछ सोचते हैं, अपनी राय कमेंट सेक्शन में ज़रूर दीजिएगा। कहीं पर अगर आपको और भी कोई जानकारी चाहिए इस मसले से रिलेटेड या इसके अलावा भी अगर आप कोई जानकारी जो है वो लेना चाहते हैं तो हमें कमेंट सेक्शन में ज़रूर बताइएगा। आप तमाम लोगों का वीडियो देखने के लिए बहुत बहुत शुक्रिया।